Good afternoon, and thank you for attending today's Panel B meeting of the Medical Board of California. My name is Jim Helzer. I'm the panel vice chair, and I'm chairing today's meeting because Dr. Thorpe is not able to attend. I'd like to call the meeting to order, and our first agenda item is to call the roll.
President.
Dr. Helzer?
Present.
John? Ms. Lawson? Here. Dr. Mahmood?
Yes.
Dr. Thorpe? We have a quorum.
Thank you. A quorum is present. Our next agenda item is to elect our panel chair and vice chair. I'd like to nominate Dr. Thorpe to continue as panel chair, and I will entertain additional nominations from the floor.
I'll second that.
Thank you. All right. So the motion is to elect Dr. Thorpe as panel chair. Is there any discussion? Let's go ahead and call the roll.
Mr.
Oh, thank you. Are there any public comments?
We got to give some comments to the board.
Mahmood?
We don't need public comments for panel.
Excuse me, this is the court reporter. Am I to be writing this now?
No, thank you.
Can you hear me, the court reporter?
So you're not going
Yes,
to
we
start
can hear
until
you.
you call the
Oh.
matter.
So I'll be when you start. Okay, thank you. I didn't.
You can go ahead and mute yourself.
Okay, thank you. I'm sorry.
Okay, we'll go ahead and take a vote.
Mr. Burks?
Yes.
Dr. Helzer?
Yes.
Ms. Lawson? Yes. Dr. Mahmood?
Yes. Thank you. The motion carries. We'll go ahead and open nominations for vice chair.
I'd like to nominate Dr. Helzer for vice chair.
Thank you. Okay. Thank you. Are there additional nominations? Okay, the motion is to nominate myself as to elect myself as vice chair. Is there any discussion? And are we taking public comment?
We should, but it doesn't look like we have any public anyway, so.
Panel, well, we have people online, but panel A, they didn't take any public comment.
Okay, let's call the roll.
Mr. Burks?
Yes.
Dr. Helzer?
Yes.
Ms. Lawson?
Yes.
Dr. Mahmood?
Yes. Thank you. The motion carries. Our next agenda item is an oral argument on a non-adopted proposed decision involving Dr. Sergio Sapetto. I'd like to turn the meeting over to Judge Larson, who will preside this portion. Thank you, Your Honor. Please go ahead.
Good afternoon. We are on the record before the Medical Board of California, Panel B, in the matter of the first amended accusation against Sergio Sapetto, case number 800-2020-069628. This is OAH case number 2022-120-556. Today is November 29th, 2023. It's 1:05 p.m. We are here at the date, time, and the location for the note set forth in the notice of oral argument. My name is Marcy Larson. I'm an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over this oral argument this afternoon. Prior to going on the record, the board members identified themselves and a quorum was established. May I please take the appearance of counsel, starting first with the Deputy Attorney General.
Harriet Newman with the Attorney General's office.
Excuse me, could I hear you again? I'm sorry. Oh, no.
So go ahead. Ms. Newman, if you would please just slowly state and spell your name for the court reporter.
Sure. It's Harriet Newman, Harriet Newman.
Thank you.
All right, counsel for respondent.
Yes, good afternoon. Albert Garcia, appearing for the respondent, Dr. Sapetto, who is present remotely.
All right, and Mr. Garcia, I will likewise have you please just state and spell your name.
Albert, A-L-B-E-R-T, Garcia, G-A-R-C-I-A.
Board has issued an order of non-adoption of a proposed decision issued by an administrative law judge and has decided to determine the matter itself. As set forth in the notice, oral argument shall be directed only to the question of whether the proposed penalty should be modified. The following process and time limitations apply. Respondent has 15 minutes to make an opening statement. Respondent's represented by counsel. So Mr. Garcia, you have 15 minutes to make an opening argument. The Deputy Attorney General then has 15 minutes for a response. Respondent will then have 5 minutes for closing argument, and the Deputy Attorney General will have 5 minutes for closing argument. These time limits will be strictly enforced by me. I will give you a 1-minute warning when your time is about to be up. The arguments shall be based solely on the existing record and shall not exceed the scope of the record that was admitted into evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that elicit new evidence. Myself and any panel member may ask a party to support a party's oral argument on the matter with a specific citation to the record. At the end of oral arguments by counsel, I will offer a respondent an opportunity to address the panel regarding the penalty. If the doctor chooses to do so, I will place him under oath first. After oral argument, the board will then go into closed session to deliberate. The parties will not receive a decision today, but will receive that decision sometime in the future. So please remember that all the arguments must be based on the existing record and no new evidence will be heard. And the board, of course, has the benefit of reading in any of the briefs that you filed. All right, any questions from me before we begin?
No,
No, Your Honor, thank you.
All right, then. Just a moment here. I'm going to start the timer and then I will notify you, Mr. Garcia, when you can begin. Are you ready?
Yes, Your Honor.
All right, you may begin.
Thank you. First of all, I want to just say that I do have a cold, so I might be sneezing and coughing here a little bit. My voice might be a little throaty, so I apologize in advance. This case, members of the panel, admittedly involves serious misconduct by respondent Dr. Sapetto, who has candidly admitted to engaging in relations with a patient in violation of Business and Professions Code Section 726. Dr. Sapetto has accepted full responsibility for his misconduct and has expressed remorse for it and has done so from the very inception. He did so during 2 board investigation interviews, and he did so again during the course of his testimony at the hearing.
Excuse me, Mr. Garcia, could you slow down just a little? I'm having trouble understanding some of the words. Connection, yeah.
Dr. Sapetto, of course, agrees with complainant that the patient's consent is not a defense to the charges of improper relations with a patient, and he has never claimed consent as a defense. But the First Amendment accusation alleges much more than relations with a patient. It goes on to allege that respondent exploited the patient, psychologically coerced her, threatened her to enter or remain in the relationship, forced physical sex on her, and obtained a quid pro quo of sex in exchange for medical services. Dr. Sapetto has denied those charges, and it is with respect to those charges only that he has maintained that the relationship was always entirely consensual. That is, that he did not exploit the patient, did not physically or psychologically coerce her, threaten her, or did anything else to force sex upon her or obtain a quid pro quo of sex in exchange for medical services. And indeed, the administrative law judge so found and determined. But let there be no misunderstanding. Dr. Sapetto is not in any way suggesting that the consensual nature of the relationship excuses his misconduct. The ensuing remarks are solely intended to address complainant's request for the ultimate penalty of revocation of Dr. Sapetto's certificate, to the extent that it is based on aggravating conduct that the ALJ determined did not in fact exist. Here is what the ALJ found regarding patient one's credibility in testifying about those alleged exploitation claims. Quote, much of plaintiff patient one's testimony regarding her relationship with respondent is inconsistent with other evidence and is, quote, not credible. Patient one testified that she began seeing respondent in person in 2018, and he offered to provide informal psychotherapy to supplement the treatment she was receiving from her Kaiser mental health providers. She characterized their monthly outings as similar to the therapy sessions with her psychiatrist. Quote, this testimony is not credible. Patient one testified that she felt coerced into having sex with respondent because he threatened to withhold ordering preoperative tests for her cosmetic surgery and delayed writing her a note to get off work. She testified that respondent forced her to have sex in a motel room in December 2018. Patient one further testified that she went to Hawaii with respondent in January 2019 for the same reason, that she feared she would not get the cosmetic surgery she desired unless she did what respondent told her to do. She testified that she continued to have sex with respondent and went to Hawaii a second time because she needed him to provide documentation to keep her disability, state disability, and that respondent physically grabbed her at least twice. She also testified that she never felt that she was in a boyfriend-girlfriend relationship with respondent, and that all sexual contact with him was against her will, and that she never intended to leave, she never wanted him to leave his partner and to marry her. Quote, this testimony is not credible in light of the numerous romantic and sexually explicit messages patient one sent to respondent during the course of their sexual relationship. Patient one testified the respondent threatened her when he found out she was pregnant, that he threatened to call immigration and have her deported, even though she's a naturalized United States citizen, that he threatened to put false information in her medical record, threatened that she would never work in television again, stated at one point that he changed his mind and offered to support her and her baby, but only if she told people she had become pregnant by a sperm donor. Patient one testified the respondent told her that he, quote, wouldn't have a that she wouldn't have a better fate, end quote, than his ex-wife who was dead. And she interpreted this as a death threat. She thought that respondent would hire, quote, a Colombian guy, end quote, to kill her. And she was afraid that respondent would take the baby and that crazy lady, referring to respondent's partner, would then raise the child. Quote, this testimony is not credible. These then are the factual and credibility determinations that the ALJ made after hearing the evidence firsthand and observing patient one's demeanor while testifying. And under Business and Professions Code Section 2335, this panel is statutorily obligated to accord great deference to those findings. That statute mandates that, quote, when considering a proposed decision, the panel shall give great weight to the findings of the administrative law judge. The rationale for this rule is pretty obvious. The ALJ had the opportunity to hear the evidence firsthand and to observe the demeanor of the witness, and on that basis, evaluate credibility and arrive at factual determinations on that firsthand assessment. Now, this panel, on the other hand, reads the same evidence from a dead page, an expression the lawyers use, and is therefore deprived of the sensory encounter with the demeanor of the witness and the tones, the shades, and gradations of testimony that imbue the testimony with credibility or the lack thereof. It is for this time-tested reason that the rule has evolved in administrative practice that an agency may not disregard an ALJ's credibility findings unless there is substantial evidence undercutting the ALJ's credibility determinations, evidence that must be of sufficient substance to support findings contrary to those of the ALJ on the credibility of the witness. Here, there's more than ample evidence, including documentary evidence, to support the ALJ's credibility determinations. I'm not going to go and revisit them here. Suffice it to say, as indeed the ALJ found, the patient one's testimony on the alleged instances of exploitation, quote, is not credible in light of the numerous romantic and sexually explicit messages patient one sent to respondent during the course of the relationship. But even in the absence of those additional aggravating claims, we're still left to deal with a very serious offense, namely relations with a patient in violation of BMP Code Section 726. And Dr. Sapetto, of course, must be disciplined for that grave misconduct. The question is what measure of discipline is both appropriate and necessary to protect the public interest and be fair to Dr. Sapetto as well. As to mitigating factors, Dr. Sapetto admitted to engaging in the relationship. He cooperated with the board's investigation. He successfully completed the UC Irvine School of Medicine Professional Boundaries and Ethics course. He has been and is currently undergoing psychotherapy, which has provided him with insight into his misconduct. He has gained an understanding of the reasons that led to his misconduct and insight into the recognition of the red flags that will alert him in the future to situations that are to be avoided and thereby ensure that he will not reoffend. In particular, he will be sensitive to any situations where there might be any inkling of mutual attraction.
Excuse me, counsel, could you slow down a little again? I'm having trouble understanding the words, please.
Okay. And I'm having trouble.
I know you have a cold, but just slow down,
Okay.
I could understand.
I'll try my best. Okay. In particular, Dr. Sapetto will be sensitive to any situations where there might be any inkling of mutual attraction, because even a consensual relationship with a client does not provide or does not override the concerns of unequal power, vulnerability, and the potential for exploitation that come with a sexual relationship between physician and the patient. Dr. Sapetto introduced 8 letters of support from physician colleagues and former colleagues, his current employer, and friends, all attesting to his good character. He served as a volunteer driver for the city of Morgan Hill for approximately 2 years, responsible for delivering meals to homebound senior citizens during the COVID pandemic. And he is current with all of his CME requirements. Business and Professions Code Section 2229 provides guidance on the question of appropriate penalty. It sets forth the standard by which to appraise the facts and circumstances of a case in order to determine whether revocation is truly the only means of protecting the public interest. While protection of the public is to be given high priority, the legislature has also decreed that in exercising disciplinary authority, the board must take action calculated to aid in the rehabilitation of the licensee whenever possible, and that it is only in those situations where rehabilitation and protection of the public are inconsistent that protection, such as the drastic measure of revocation, shall be paramount. There is nothing in the record to indicate the rehabilitation of the respondent and protection of the public are irreconcilable. Though concededly grave, Dr. Sapetto's misconduct occurred with one patient, and his last involvement with the patient was more than 3 years ago. He has no other disciplinary history. He has undertaken considerable rehabilitative work to address the causes that led to his misconduct. Dr. Sapetto is well respected for his integrity, compassion, and professional competence, as evidenced by his letters of support and the character witness testimony that was presented. And I respectfully emphasize that as of January 1 of this year, Business and Professions Code Section 2307 has been amended to provide that, quote, the board shall not reinstate the certificate of a person under any of the following circumstances, including subdivision B, the person's certificate has been revoked based on a finding by the board that the person committed an act of sexual abuse, misconduct, or relations with a patient pursuant to Section 726. This is a death knell. A revocation would be a death knell. Dr. Sapetto would never be able to petition the board for reinstatement of his California certificate under this amended statute. So Dr. Sapetto respectfully requests that he be given a second chance to prove that he can and will practice in accordance with the highest ethical standards, and that his license not be forever revoked here in California, and would now be required as would now be required by the code section that I just quoted. Dr. Sapetto respectfully submits that the ALJ's proposed disciplinary order is fair, is reasonable, and it adequately protects the public interest, and is in conformity with the suggested penalties set forth in the Manual of Disciplinary Guidelines, Model Disciplinary Guidelines. So, panel members, once again, yes, this was a very, very serious case, serious misconduct. Dr. Sapetto does not in any way deny his responsibility. He has never pointed a finger at the patient. He has taken all responsibility, expressed remorse for it. He has had no other issues of any kind, whether they be sexual, as in this case, or have anything to do with substandard patient care. Since this incident, which happened, the last involvement with the patient was in 2020. Thank you, Your Honor. So yes, grave situation, grave misconduct here, but Dr. Sapetto is still a relatively young man, and to revoke his license forever here in California it goes beyond just protecting the public, and it starts to look a lot like a punitive measure, and that's what the complainant is requesting. I think it's unreasonable under the circumstances of this case. Thank you, Your Honor.
All right, Ms. Newman, please let me know if you are ready and I will start the time.
Okay, thank you, Your Honor.
All right, you may start.
The facts in this case are simple. Dr. Sapetto was patient one's doctor. After her first visit to him in his office, he initiated a relationship with her outside of the doctor-patient relationship. The relationship turned sexual, and Dr. Sapetto admitted to having a sexual relationship with the patient. He admitted to having sex with her on multiple occasions over an extended period of time, including having sex in his medical clinic while he was on duty. Once the sexual relationship began, Dr. Sapetto never removed himself as her doctor. During the relationship, the patient at one point had lost her job, and then her Kaiser insurance had ended. Later, she was able to re-enroll back with Kaiser, but instead of assuring that the patient was assigned to another doctor, Dr. Sapetto remained, once again, he became her primary doctor again. In doing so, he continued the power imbalance that exists between a doctor and a patient. After the patient became pregnant, Dr. Sapetto admitted to having an appointment with the patient, not showing up to the appointment, and instead he falsely recorded in the records that she was a no-show, not him. He testified at the hearing that it was, quote, another example of my inappropriateness in this relationship. And in doing so, he committed dishonesty and he falsified records. The patient testified to being afraid of Dr. Sapetto. And the strongest evidence we have of Dr. Sapetto's threatening and inappropriate behavior occurred 3 years after the relationship ended. Earlier this year, when Dr. Sapetto admitted that he flew across the country to attend a deposition of the patient in a civil matter. And he admitted that he did so for the sole purpose, he admitted that he flew across the country for the sole purpose of attending her deposition. When he was asked why he flew across the country to attend her deposition, he said he didn't think she'd be able to testify with him in the room. Dr. Sapetto admitted that his intent in being there was to intimidate the patient. We're not suggesting that Judge Reichman's findings be disregarded. Even in light of the findings from the hearing, revocation is appropriate in this situation. Dr. Sapetto was her doctor and she was his patient. Evidence was presented that she had various mental health issues that she had been seeking help for, including anxiety, depression, and an eating disorder. She recently had several losses in her life, and she additionally, as the relationship progressed, she lost her job. Dr. Sapetto knew this, and this made the relationship even more unbalanced, precarious, and all around inappropriate. The patient was an extremely vulnerable person, and she was looking for help at this point in her life. The board's expert, Dr. Brody, testified that Dr. Sapetto used his unique privilege as her physician and privy to her vulnerability to engage in a sexual relationship with her. The judge's factual findings that the patient was not credible don't change the facts of this case. We still have Dr. Sapetto's own admissions to initiating a sexual relationship with a vulnerable patient struggling with mental health issues, to falsifying the patient's medical records, and to flying across the country years after the relationship ended in order to intimidate the patient. He refused to give up, and years later, his inappropriate behaviors continued. According to Business and Professions Code Section 726, any acts of sexual abuse, misconduct, or relations with a patient constitutes misconduct and grounds for disciplinary action, as Mr. Garcia stated. According to a 2011 Superior Court case, Roy versus Superior Court, the purpose of this statute is to protect vulnerable patients from overreaching by their physicians who occupy a position of dominance or relative disparity of power in the physician-patient relationship. And that's exactly what happened in this situation. Not only did Dr. Sapetto's conduct violate the Business and Professions Code, but his conduct was also unethical per the Code of Medical Ethics, which states that such interactions may exploit the vulnerability of the patient, compromise the physician's ability to make objective judgments about the patient's health, and ultimately be detrimental to the patient's well-being. In order to protect the well-being of other vulnerable patients, such as the one in this case, who might come into contact with Dr. Sapetto, Dr. Sapetto should not be trusted with the privilege of a medical license. Simply issuing him a probationary license will not protect such patients. The only way to protect all patients from Dr. Sapetto's overreaching behavior is to remove him from his position of dominance and disparity of power. His license should be revoked. The egregious nature of his actions combined calls for revocation in this matter. Thank you.
All right, Mr. Garcia, you will have 5 minutes for a closing argument. Please let me know when you are ready. You're muted.
I'm ready, Your Honor.
That's why we always check before we start the clock.
Thank
All
you.
right, you may start.
Thank you. Members of the panel, it's very unusual for me to call opposing counsel a misrepresentation of the record, but I'm going to do so right now. The statement that Dr. Sapetto admitted his intent to intimidate the patient when he attended a deposition on the other coast, he never admitted any such thing. He stated that he went and attended that deposition because he thought that in his presence, she would not lie. She would not lie and say the things that she had said to the board. That's the reason he went. He said, I want to be there. I want to put face to face and see if she'll make those statements again. He never said he was there to intimidate her. Never said that he was admitted that he was intimidating her in any way. So that's a misrepresentation of the record. And since counsel has emphasized it, I think the panel members should look at the record very clearly, look at the record, at the reporter's transcript for that portion of the testimony, and you will see that there's no such admission by Dr. Sapetto that he flew across the country to intimidate the patient during her testimony, her deposition testimony. Now, it's true. We've conceded all along that this is a very, very serious offense. Nobody's trying to downplay this in any way. A sexual relationship with a patient is improper. It's wrong. And one of the reasons it's wrong is because, yes, there is that potential for the doctor's objective judgment to be impaired when he's in a relationship with a patient. Now, I want to point out to the panel members that in this case, the patient saw Dr. Sapetto in person at Kaiser, I believe, on 2 occasions. I could be wrong about that, so I don't want to misrepresent the record. It might be 3, but I think it was 2, and the third one was a telephone call. One visit was for a lesion, a skin lesion. The other one was for a persistent cough. That's it. So, and if it had only been one visit, it still would be inappropriate, obviously, for the doctor to engage in this kind of conduct. But to suggest that his medical judgment and clinical judgment was impaired because of those 2 visits, I think it's beyond the pale in this particular case. And not to suggest in any way that the conduct that Dr. Sapetto engaged in was appropriate in any way. It was inappropriate. It was wrong. We've never shied away from saying that. We've always admitted that. We've always conceded that. Now, Dr. Brody, the expert, testified that his opinions in this case were based on the assumption that the patient was telling the truth about these claims of coercion, intimidation, threats, and all the other allegations that were made. He testified that according to the expert guidelines that the medical board provides, that he is to assume the truthfulness of those allegations, and that he assumed those allegations when he wrote his report. And I cross-examined him at length about the inconsistencies in the patient's testimony, both at the hearing and her deposition testimony. And over again, the doctor would say something along the lines of, I didn't know that, I didn't have the deposition. So he was unaware of those inconsistencies. But the bottom line is, yes, Dr. Brody rendered an opinion, but he admitted on the witness stand that his opinion was based on the assumption that the claims made by the patient were true. The judge who heard the case, the administrative law judge, found
1
they were
minute.
not credible. Is that it?
1 minute.
Okay, thank you. The administrative law judge listened to that testimony, and she heard all the testimony. She heard everything about the deposition testimony back east, and Dr. Sapetto attending it. She heard all that. And when it came down to the bottom line, her opinion was that this patient was not credible about these other aggravating allegations that she made. That does not take away from the fact that there was a sexual relationship that has never been denied by Dr. Sapetto. It's there. It was wrong. Does it warrant revocation of his license forever here in the state of California, given the fact that, all the mitigating circumstances that are in the record, and the fact that this last visit was 3 years ago, last encounter was 3 years ago, with no other issues of any kind? No, I would say no. There is room here for probation, place the doctor on probation of whatever conditions this board
Time,
deems
Mr. Garcia.
appropriate. Okay, these are appropriate for protection of public interest.
Mr.
Thank you.
Garcia.
Thank you.
Ms. Newman, please tell me when you are ready.
I'm ready.
You may start.
Just to address Mr. Garcia's misrepresentation of the record claim, in the transcript, there's evidence that Dr. Sapetto did state that when asked why he flew across the country to attend the deposition in New York, he did say that he didn't think patient 1 would be able to testify with him in the room. And that in itself is equal to intimidation. Him flying across the country for no reason than to hopefully prevent the patient from being able to testify to the events that happened and to what actually happened is the definition of intimidation. There's no other reason why he would fly, and he had no other reason to explain his flying across the country to attend the deposition. As far as how many visits the patient and Dr. Sapetto had together, that is of no consequence. Whether he had 1 visit, 10 visits, 5 visits, Dr. Sapetto was the patient's doctor, and he examined her, and he had complete access to her records. That is what a physician does, and he had access to all of the patient's records, and that puts him in a that's the definition of a physician-patient relationship. Seeing the patient, having access to the records, having a physician-patient relationship. As far as Dr. Brody, as I mentioned earlier, he testified that all of patient one's communications, any communications that she may have had or she may have sent to Dr. Sapetto, is not evidence of her untruthfulness, but all of that speaks to her vulnerability. He focused on the vulnerability of this particular patient, and in this case, we have a very vulnerable patient. Again, probation is not appropriate in this case, and in order to protect the public, Dr. Sapetto's license should be revoked.
Mr. Garcia, does Dr. Sapetto wish to address the panel members with regards to the penalty?
Yes, Your Honor, he does.
All right, Dr. Sapetto, the first thing I need to do is swear you in. You would please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
You may lower your hand. Please state and spell your name.
My name is Dr. Sergio, Sergio, Sapetto, Sapetto.
All right, Dr. Sapetto, you may address the panel members with regards to the issue of the penalty.
I've prepared a statement here. You'll bear with me.
So just be mindful, we have a court reporter, and sometimes when you read a little faster than you would speak. So just please read very slowly, keep your voice up, and do your best to enunciate your words so it makes it as easy as possible on her. We can make sure that our panel members are hearing you as well. Do you understand?
Yes, thank you, Your Honor. Thank you for this opportunity to provide a statement about the case and the events that transpired. I find it very difficult to summarize in just a few sentences my full understanding and feelings surrounding the inappropriate relationship I had with my former patient, but I understand there are time constraints. Expressing my true thoughts and feelings are not always my strong suit, especially in a highly stressful forum such as this, but I will strive to do my best. First off, I want to make it very clear to the medical board that I accept full responsibility for my actions. There are absolutely no excuses for my behavior. What I did was wrong in so many ways, ethically, morally, professionally, and more. My actions damaged and hurt so many people. My former patient, my family, my profession, my employer, and myself. I apologize in the sincerest way that I can to all those affected by my actions. And not a single day of my life passes that I don't think about these events and their repercussions. My life, my thoughts, my very essence of being human has been changed irrevocably forever. I want all those here today to know that I am utterly and fully committed to doing everything possible to ensure nothing like this will ever happen again. I've been to the bottom emotionally and mentally of myself in search of answers to why this happened, to ensure this cannot and will not ever occur again. I've had professional counseling, taken a professional and boundaries and ethics course, and reflected heavily. I have, through this, learned more about myself and my personal vulnerabilities, practice style risks, and professional boundaries that will guide all my future decisions and actions. I have learned to identify red flags, such as situational and emotional factors, type of practice, work environment, and my own life stressors that put me at risk. I have ingrained in myself the steps I need to take in order to minimize and eliminate these risks. And all this I have written down and made a personal protection plan to further ensure that there will be no more transgressions of this type in the future. In conclusion, I want to reassure the board that I am given a second chance, that it will not be wasted. I am fully committed to proving that I am a caring, trustworthy professional, healthcare provider, and human being, and that I can continue to be a contributing member of society and to my community. Thank you for your time and attention.
I'm now going to ask our panel members if they have any questions, starting with our vice chair.
Thank you, Your Honor. I have a question for Mr. Garcia. Mr. Garcia, in Ms. Newman's written argument, she asserts that Dr. Sapetto violated Business and Professions Code Section 729, which in my understanding defines any sex between a physician and a patient as sexual exploitation. How would you respond to that?
Well, the violation here, I believe, is 726, relations with a patient. All of the allegations that have to do with, well, he actually has sexual relations with a patient, yes. But the question is, did he exploit the patient in the way contemplated under 729? And that were all the threats of coercion, the use of his authority as a physician over her to gain an advantage. That's where all those factors come in. And my answer is no, that didn't happen in this particular case. There was, yes, a violation of 726, but as to the exploitation of the patient under 729, the facts are not there for that particular offense.
Thank you. I have no further questions.
Thank you.
Mr. Brooks, any questions?
I do not have any questions. Thank you.
Ms. Lawson, any questions?
Yes, just one question. I think it's for Deputy Attorney General Newman. With respect to the issue of the deposition and flying across the country, I do see some reference in the record to that, but was there a finding made by the administrative law judge in the proposed decision in that regard?
I don't believe that the administrative law judge made a finding one way or the other about that.
Okay, thank you.
Right. And Dr. Mahmood, do you have any questions?
Yes. If this is not inappropriate rest, how is the victim doing now? And how does she feel about this?
So I'm going to have not allow that question just because it's outside the scope of the record, unless in fact there was testimony in the record that relates to, at the time of the hearing, she discussed how she was doing. So if you want to rephrase it at the time of the hearing, and if that was presented as evidence, I can allow that.
Thank you. I totally understand. I have no more questions.
Mr. Brooks?
My apologies. I have one question that came to mind as Dr. Mahmood was speaking. It does relate back to the issue of this deposition that Deputy Attorney General Newman raised. And is it correct that that was in connection with a civil suit and not in connection with this medical board proceeding?
That's correct.
Thank you.
Mr. Brooks?
I just want to address that. It is in the reporter's transcript. There's testimony in the reporter's transcript concerning that trip to the East Coast when the patient was being deposed in a civil case. So it's in the reporter's transcript.
Mr. Garcia, that question wasn't posed to you. That was question was posed to Ms. Newman, and she answered the question.
I was just trying to help out.
If Ms. Lawson wants to follow up with you, she can. But at this time, that was a question for Ms. Newman.
All right, thank you.
Perhaps it is worth me following up. So, I mean, just a question there. Was Mr. Garcia counsel for the physician in that civil lawsuit?
Was that counsel for him in that deposition? Is that the question?
In this civil
In that,
lawsuit.
in connection with that, in
Oh,
connection with
no,
that
no.
matter, yes.
No,
Okay.
I was not involved in the civil litigation at all, not at all.
I guess I'm a little bit, this is more of a statement, I'm a little bit confused about why this is being raised. It looks like from the reporter's transcript, there was an agreement between the counsel in that case for people to appear at the deposition, including the physician. But again, we don't have anything in the ALJ's decision on that point. We just have the transcript from that deposition. Just
Right.
that's not a question.
Right, which is part of the record, so you could consider that.
I understand.
Mr. Brooks?
Yeah, I do have maybe it's more of a technical question. When the patient lost her Kaiser benefits and came back, what was the process? It's maybe for your attorney or Dr. Sapetto. What's the process of getting that same patient back to the same doctor? Is it administrative? Did the patient ask for Dr. Sapetto? Did Dr. Sapetto reach out and ask that he continue care of that patient?
May I answer that?
Yes.
As far as I understand, it's automatic at Kaiser.
Repeat, I couldn't hear you.
Automatic.
It's that's correct.
It's automatic.
It's automatic.
No, because there was a testimony that you had requested patient one to be your patient again after her insurance came back into good standings. And you're saying that is not correct. The system automatically puts you back with patient one.
Yes, it's automatic.
All right. Thank you.
Any further questions from our panel members? No further questions? All right, then, Mr. Garcia, is the matter submitted?
Try to submit it.
Matter submitted, Ms. Newman?
Yes, Your Honor.
Matter submitted, and the record is closed. We are off the record.
Thank you.
All right, thank you. Do we want to go ahead and just break till 2 and then give everybody an opportunity to join?
Okay, we'll recess till 2 p.m. Thank you.
All right, thank you.
Great.
All right, then. I'll go ahead and have our vice chair just go ahead and announce us, and then I will take it over.
Thank you, Your Honor. Our next agenda item is an oral argument on a non-adopted proposed decision involving Dr. Sean Siburn. Judge Larson, please proceed.
Okay. All right, we are on the record before the Medical Board of California, Panel B. And this is in the matter of the accusation against Sean James Siburn. This is Medical Board case number 800-2021-084208, OAH case number 2023-030697. Today is November 29th, 2023. It is 2:05 p.m. This is the date, time, and place set for oral argument in the notice of hearing for oral argument. My name is Marcy Larson. I'm an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over this matter. Prior to going on the record, the board members identified themselves and a quorum was established. May I please take the appearance of counsel, starting with the Deputy Attorney General.
Good afternoon, everyone. Thomas Osley, Deputy Attorney General.
And counsel for respondent.
And my name is Marvin Firestone, and I'm representing Dr. Sean Siburn, and with me is my associate, Jeff Lewis.
And Dr. Siburn is present as well, correct, Mr. Firestone? Yes, he is. All right, the board has, in this matter, has issued an order of non-adoption of a proposed decision by the administrative law judge and has decided to determine the matter itself. Oral arguments shall be directed only to the question of whether the proposed penalty should be modified. The following process and time limitations apply. Respondent has 15 minutes to make an opening argument. And respondent, of course, is represented by Mr. Firestone, so you have 15 minutes. The Deputy Attorney General will then have 15 minutes for a response. Respondent has 5 minutes for closing argument, and the Deputy Attorney General has 5 minutes for closing argument. These time limits will be strictly enforced by me. The arguments in this matter shall be based only on the existing record and shall not exceed the scope of the record of admitted evidence. No new evidence will be heard. The panel members may ask questions of the parties to clarify the arguments, but may not ask questions that elicit new evidence. Myself and any panel member may ask a party to support the party's argument on the matter with a specific citation to the record. At the end of oral argument by counsel, I will offer Dr. Siburn an opportunity to address the panel regarding the penalty if he wishes. And if he does so, I will place him under oath first. After I offer the panel members an opportunity to ask any questions, the matter will be submitted and the record closed, and the board members, panel members will go into closed session to deliberate. The parties will not receive a decision today, but sometime in the future. All right, any questions for me before we begin?
No, Your Honor.
Mr. Firestone?
None at this time, Your Honor.
All right, so I'm just going to remind everybody, we're all appearing remotely, so just please do your best to keep your voice up, to speak slowly so it's easy for our court reporter to take down everything that's being said, and we ensure that our panel members can hear everybody clearly, all right? All right, Mr. Firestone, tell me when you are ready and I will start the time.
I'm ready whenever you allow me to proceed, Your Honor.
All right, you may start.
Members of the Medical Board of California, my name is Marvin Firestone and I represent Dr. Sean Siburn. Dr. Sean Siburn is a young physician who had been in training at UCSF with a training medical license during the first years of his residency in anesthesiology at UCSF. While he was in the process of applying for a full practice license in order to complete his residency training, he was issued an accusation by the medical board. The accusation was not related to his provision or participation in medical care, but occurred as a result of his getting together with an old friend with whom he had an on-again, off-again relationship when the two of them were in New Jersey, and he was attending Rutgers University Medical School. For reasons that were poorly thought out by Sean, he secretly recorded the sexual relationship he had with his old friend on the night they got together. That friend discovered his cell phone videoing them and became irate. The old friend reported him to the police, to Sean's residency program director, and to the medical board. The police took no action against Sean. After investigation by his residency program at UCSF, it took no action. The medical board's investigation, however, led to an accusation against him, although admitting that his improper act had nothing to do with the provision of medical care. Unfortunately, because his application was held up by the medical board during the pendency of the accusation that had been filed, this residency program was terminated due to his not acquiring the required medical license to continue his training. During the investigation by the medical board and at the hearing before the administrative law judge, Sean had the fear that if he admitted videoing the relationship with his friend without his permission, he would then be arrested and would have been criminally issued a conviction of a misdemeanor for the situation by admitting the video without receiving his friend's permission. And he believed that that would lead to termination of both his license and his residency program. Consequently, at the hearing, he denied that he videoed the relationship with his friend, and the administrative law judge believed his friend's testimony over his testimony due to several inconsistencies in his testimony and the evidence that was presented. Sean is here to share with members of the Medical Board of California the circumstances in which he finds himself and tell you what he has learned as a result of this situation. He is contrite and will be asking this panel not to mete out a harsh discipline that will preclude him from continuing in his residency and fellowship training in anesthesiology. I'll let Sean present his statement, and then he'll be happy to respond to any questions or concerns that you have. Sean?
Good afternoon, members of the California
So-
Medical Board. My
So
apologies.
just if you're going to be turning over your time, the remaining 10 minutes you have, I'm going to need to swear the doctor in. So if you would please raise your right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I swear.
All right. And you have 10 minutes and 43 seconds remaining on the time that Mr. Firestone started. You may begin.
Thank you, Your Honor. My name is Sean Siburn. Thank you for the opportunity to speak before you today. I stand before you and accept the factual findings by the administrative law judge. This has been the biggest life lesson that I have ever experienced, and I take full responsibility for my actions. It was wrong, and it does not follow any pattern of behavior that I have ever previously demonstrated. I wish to share information about myself with you today so you have a better sense of who I am as a person and how my poor decision that led to the accusation against me is a major outlier in my behavioral history as an individual and as a physician. I think it's important to share why I ended up choosing a career in medicine. I studied anthropology in college and loved the sciences. During my college years, my mom was diagnosed with breast and uterine cancer. At her bedside, I observed that her anesthesiologist sat down, looked her in the eyes, and listened to my mom as an individual, not just as a patient. Surgical pre-op areas are nothing short of a hurricane of chaos and turnover. That experience of witnessing that anesthesiologist stop, sit, and listen has served as my core foundation for every interaction I have with my patients. That anesthesiologist validated my mom's fears, but also invigorated us all at the bedside with a sense of trust and calm. This was a foundational role model for me in my career. My favorite moment of work as a doctor is getting to meet my patient right before surgery. No matter how hard of a day I am having, I always think back to that experience with that anesthesiologist at my mom's bedside. I stop, I sit, and I listen. And it's been a privilege to meet someone and establish a line of trust on potentially the worst day of their life. I do everything in my power to validate their concerns and get to know something about them. I'm always grateful to learn something about the patient, and it further invigorates my passion to help others. It has been a privilege of a lifetime, and the role of an anesthesiologist is a gift. I wish to be able to serve that role again. Residency training as a whole is a brutal experience. There's a lot of exposure to stress, sleepless nights, and burnout. Many of you today can certainly think back to those years of training and remember how challenging and taxing that experience was. My 3.5 years of residency brought me the highest highs and lowest lows. Unfortunately, my intern year coincided with the start of the global pandemic. Although I do not wish to make excuses, I do wish to convey that this pandemic was unparalleled and completely destroyed the mental health of every single healthcare provider I encountered, including myself. Although physicians are exposed to much suffering, death, and dying, I, along with all healthcare providers during the pandemic, was exposed to a level of death and sickness I couldn't have previously fathomed possible. One unforgettable memory that I personally had was performing death exams on several COVID patients on the same day while their families watched their loved ones die over a Zoom call because the ICU was not safe enough to have visitors. This was before vaccines for COVID were available. Healthcare providers had to process what was going on and grieve alone. The world was shut down. The ability to alleviate stress and reinvigorate happiness was limited, if not impossible. I did my best to sweep burnout and depression under the rug, which inevitably became an awful elephant in every room I had to walk into. I thought my mental health would never be worse than during COVID, but this experience has pulled me into the depths of depression and despair that I didn't even know were possible. What I did, I now know was selfish, and it was ethically and legally wrong. My decision to betray Kian's trust has brought nothing but suffering for many. It was by far the worst decision I have ever made. I regret it, and self-shame consumes my every thought on a daily basis. It is the first thing that comes to my mind when I wake up, and the last thing on my mind as I attempt to go to sleep each night. Most days I feel completely numb. I've lost 60 pounds since the beginning of this year. I have nightmares that awaken me screaming more nights than not. I have no active plans of hurting or killing myself, but I must admit those thoughts often go through my mind. My life has fallen apart because of my stupid and careless choice. I was fired from my residency program in January of this year for not having an active medical license, since processing of the application was held up during the pendency of the accusation against me. Additionally, I was dismissed from the fellowship in which I was accepted as a result of not being able to complete my residency program. I have worked tirelessly and have sacrificed my entire life to achieve the dream of becoming a doctor. There is complete uncertainty of my ability to ever return to UCSF as a resident. The credentialing committee will have to evaluate whatever the final ruling by the medical board is and determine what they believe is best for the residency program and for me. A harsh ruling would all but seal my fate and prevent me from ever returning to a residency program. At best, I would have to wait for another year and reapply through the match, and then be able to prove I am rehabilitated from what led to this accusation against me. I'm under extreme financial pressure living in San Francisco. I'm now working a minimum wage job and I'm making just enough money to pay rent and purchase some groceries. I'm in newfound credit card debt. It's been challenging to find any work as I'm recurrently told I'm overqualified and employers can quickly use the internet to find out why I am no longer in a residency training program. Currently, I'm working at a gym and spend my days on hands and knees cleaning gym equipment and bathrooms. This is a vast departure from my being a resident in training, and the experience has been humbling to say the least. My parents are also suffering, experiencing financial pressure, and are currently planning to sell their home in order to help me pay my legal bills and provide support for me. My bad act has completely destroyed their lives in retirement. I have brought public shame not only to my own life, but to theirs as well. It has been devastating for my entire family, and my sister, who has always been my best friend, has refused to speak to me in months. I cannot understate how this has completely torn apart my family. During my time away from practice, I have done everything I can to seek personal and mental growth. I voluntarily participated in the Western Institute of Legal Medicine's immersive course on medical ethics and professionalism beginning in January of this year. The program is approved by the medical board, and I've received 23 continuing medical education credits for my participation from UC Irvine. I've learned a lot, and I truly wish a lot of this information had been taught to me in medical school and during my residency training. I would recommend this course to every physician and any healthcare provider I encounter, as it educates everyone on how to best prevent patient harm and provide tools to self-evaluate one's own ethical behavior. I truly believe I have grown as a person from my participation in this program. I've completed a 6-month follow-up program and will have completed a 12-month follow-up aspect of the program next month in December. I have done my best to incorporate the lessons learned into every experience I have on a daily basis. I now meditate, reflect, and journal every day. I reclaimed my lost faith and have found my church to be a crux in my journey towards forgiveness. Unfortunately, I cannot afford a therapist on my current salary. Exercising, journaling, and prayer serve as a small rung on the ladder leading me out of the darkness, but I know there's a lot of climbing yet to go for me. I stand before the board begging for a second chance. I made a mistake, a horrible choice, and I have learned the biggest lesson of my life. I have lost everything, and I can vow to the board I will spend the rest of my life working every day to prove I'm a good person who made a bad decision. I truly believe that without the darkness and despair of my training during the pandemic, the idea to do such a thing as videotaping my relationship without permission and then denying the accusation would never have crossed my mind. Rather than doing drugs or drinking like every single healthcare provider I knew at the hospital was doing to process their trauma during COVID, I elected to cheat on my fiance and have an affair. My ex-fiance called off our engagement and left me because of my decision to cheat and shame from the public fallout of my firing from residency. Having an affair was a rash decision. However, it did help a bit to drag me out of the depths of my depression and burnout during COVID. I rashly and irresponsibly wished to capture a moment of that happiness to remember what it was like to feel alive. It was selfish, it was morally and ethically wrong, and it completely disregarded the vast amount of respect I had for Keon. Words cannot begin to express how sorry I am for that poor decision. Communicating and spending time with Keon brought me glimpses of happiness during the pandemic, but my decision to betray his trust has brought nothing but suffering, darkness, and regret into the lives of many. I assure you that I have never filmed myself or others without their permission at any time prior to this experience, nor since. This action did not take place with a patient. I want to emphasize that. This event occurred outside the practice of medicine. I find the bond between physician and patient to be sacred. I am committed to honest, credible interactions with colleagues and patients. This has nothing to do with my good record of patient care. Anesthesia is one of the unique...
1 minute.
Thank you, Your Honor. Anesthesiology is one of the unique specialties in which there are always other members of the healthcare team in the room anytime a patient is under the influence of anesthesia. There will always be someone trained in ACLS and BLS during induction, maintenance, and emergence from anesthesia aside from the anesthesiologist. As an anesthesiologist, I am unable to start anesthesia and need another member of the team available for potential assistance as well as in case an emergency arises. As a result, anesthesiologists are uniquely always supervised by others. These others can include nurses, surgeons, scrub techs, anesthesia techs, CRNAs, anesthesia assistants, anesthesia residents, PAs, NPs, and OR staff, to name a few. I'm going to stop there, Your Honor.
Right. Mr. Osley, please tell me when you are ready.
Yes, Your Honor, I'm ready.
You may begin.
Thank you. So I'm going to deviate from the prepared remarks that I made, the statements of the defendant, or Dr. Siburn.
Uh-oh.
Mr. Osley, we've lost you.
Oh, I can hear you.
Yeah, you completely cut out. The last thing I heard was statements from and then you cut out.
From Mr. Siburn.
Okay, yeah, so I don't know if it's just me, but you seem to be coming in and out, so I'm not.
Should I switch audio to call in?
Yeah, because you're freezing also, so I'm concerned that.
Your video is all blurry.
Yeah, let's go. We're gonna go off the record. We're gonna let you rejoin off the record.
Okay.
All right, let's go ahead and have him rejoin, and then we'll start over.
Mr. Osley, you're back on, but you're on mute. But I can still see your video has like some blurriness to it, like you might be having some bandwidth problem.
Yeah, it's been working fine on my end. Everyone's been very clear. I've called in. Is the audio coming through okay?
It's much better.
Yeah, the audio is coming through clearly. And you can leave the video on it. It won't disrupt your audio at this point. But yeah, your video might be cutting in and out. We'll just let everyone understand that's going to be the case.
Would you like me to proceed, Your Honor?
We're off the record, so we're just gonna make sure our court reporter's ready. We'll go back on, and then I'm gonna start the 15 minutes, right? As soon as our court reporter tells me she's ready.
I'm ready.
All right, on the record. All right, we're back on the record. Mr. Osley has called in and audio is working fine. So Mr. Osley, tell me when you are ready.
I'm ready, Your Honor.
All right, you may begin.
So, Your Honor, I'm going to deviate from my prepared remarks, given the statement that Mr. Siburn just made. And I have a few observations that I want to address. The first being, this wasn't simply a denial of the accusation that went on for months. The ultimate culmination of Mr. Siburn's conduct was to subject the victim of his conduct to cross-examination at a hearing, denying that the victim was telling the truth. But it went beyond that. The victim, an African-American male, it was insinuated that he was violent, that he was pursuing a relationship with Mr. Siburn when that was not true, that Mr. Siburn's roommate was in fear of the victim, which again was not true and not testified to. In fact, the investigator in the case testified that Dr. Raja, the roommate of Mr. Siburn, only expressed a fear of Mr. Siburn, but she did not express any fear or intimidation of the victim. So this isn't simply a denial of what happened to avoid any criminal liability or accountability. It was an assault on the victim. And not just the accusations, but the gaslighting. I mean, there was a whole different story made up of whole cloth. This isn't a case where facts occurred that could be perceived in two different ways. There were two distinct stories. One told by the victim repeatedly to different sources, the police, the administration at UCSF, and each time the story was consistent. It was said without knowledge of what other evidence might exist. And even when the evidence wasn't favorable to the victim, there was candor. And then that could be juxtaposed with Mr. Siburn, who refused to divulge information during his interview. He made misstatements about how many roommates he had, for instance. He said that there was one roommate, but then referred to him as them. He said that Mr. Siburn was loud and aggressive at the hearing. None of these things were said up until the hearing so that they could be investigated, that Mr. Siburn's version could be verified if true. None of that was done. He used the resources of the medical board, the Department of Consumer Affairs, the Attorney General's office. He used the resources and the emotional resources of the victim, essentially victimizing them again by not only denying the truth, but insinuating that he was somehow a violent and aggressive individual, and that Mr. Siburn was the one entitled to sympathy because of this scary African-American male, when in truth, it was Mr. Siburn who victimized him. And to come now and admit all of these things without acknowledging not just the initial conduct that victimized the victim, but the fact that he put him through a hearing, that he sat there and watched him be cross-examined, essentially accused of lying about the interaction. He watched all of this happen and did nothing. And not until now has he admitted the truth. So I don't have anything more to say on this except for that point and one other, which is this idea that the conduct was not related to the profession. I believe the expert, Dr. Namba, did a very good job of explaining and providing the authority and cited to resources which are part of the record that anesthesiologists don't just have a duty to their patients. They have a duty to their coworkers, to their employers, to the community. And they have a duty to act with integrity, with honesty. And none of those things have been exhibited by Mr. Siburn. On the contrary, he has demonstrated that when he is in trouble or if there is an issue, he won't simply deny that he did what he did, but he will become the aggressor and go after anyone who accuses him, going so far as to make false allegations against his accusers. And so if anything has been uncovered or shown by the oral argument, I don't think it cuts in Mr. Siburn's favor. It shows a callousness and a disregard for his victim that is inconsistent with the practice of medicine. Submitted.
Mr. Firestone, are you going to be giving the closing argument?
I would like to just respond to
Hold
some
on,
of
hold
the
on.
issues.
I just want to confirm that it's you as opposed to Mr. Siburn. Yes?
Well, I think Dr. Siburn may also have some comments.
Well,
from
you
his-
have 5 minutes. How you
Okay.
divvy it up is up to you. Are you ready?
Yes.
You may begin.
The statement by Mr. Osley was basically this was not simply a denial of the accusation, and that Dr. Siburn alleged that the friend of his was violent. I think you'll hear Sean admit that he gave a different story than was factually, and the story he gave was factually untrue because he felt he had to provide an explanation for the allegations made against him that he thought was valid at the time. My cross-examination of Dr. Siburn's friend and my presentation of arguments did not say anything adverse about his friend, nor did I claim that the friend lied. I avoided taking that position during the hearing. And I think Mr. Osley knows that. And I'll let Sean add to that in response to Mr. Osley's statement.
But I understand that my choice to
I'm sorry, you have 3 minutes and 20 seconds.
Thank you, Your Honor.
And I want to remind you that you should not be providing any statements about any evidence that's outside of the record. This is all based on what's in the record, please.
I understand that my choice to take advantage of Keon's trust and lie about it seriously undermines my trustworthiness. And I understand that I will need to prove I am trustworthy and that my poor choice was a complete anomaly in the entire history of my life. I stand before the medical board begging for a chance to prove to you that I am a good person who made a bad decision. I vowed today and forever moving forward that I will not let the medical board down. I am begging for the opportunity of a second chance that I may serve as an example of change and rehabilitation for all current and future healthcare providers that I may encounter. I am deeply sorry for my actions. I will not let you down. This is completely outside of anything that I have ever been a part of. Medicine is my passion, it is my dream. The stress and burnout of COVID got the best of me, and I will be eternally sorry for everything that I've put Keon Jackson through with my entire being.
Please don't use his name. We're going to strike that. Please don't use his name.
My apologies, Your Honor. That being said, things that were in the record as well, things did get violent that night. And then I was cyberstalked for many, many months by Keon Jackson as well, which we talked about in the record.
So Mr. Siburn, I asked you not to use his name. He should be just please.
I'm really
Your
sorry, Your Honor.
friend or the victim. Please strike that.
My apologies. I'm very overwhelming. I'm really sorry for everything. And I want the board to know that my entire life has been destroyed and ruined over this horrible decision. I regret everything, and I will do anything for the ability to prove to you, to prove to patients, to prove to everyone in my life that I am a good person, and I will not let this second chance go to waste.
Mr. Osley, please tell me when you are ready.
Ready, Your Honor.
You may start.
So there were two things that stood out during the hearing. One was the testimony that the victim had to be thrown out in the hallway in his underwear because he was belligerent and raising his voice and whatnot. So it was both testified to and addressed during testimony, these allegations of him being violent. So that is not something that I am making up that is not in the record. It was inconsistent because Dr. Raja was in the next room. And I believe it's in the decision itself even references that he was testified to be 15 feet away, but wasn't aware that somebody was over at the time. So it's completely inconsistent with this physical altercation that was described by Mr. Siburn. During cross-examination, the victim was asked if he works out, how physically fit he is, all of those going toward questions regarding his physical ability to inflict injury upon somebody. And to this idea that the only way to avoid liability and to protect yourself from your bad actions is to impugn the integrity and credibility of another person, it just doesn't pass the straight face test. If Mr. Siburn would have come forward and said, yes, I did record you, but I thought I would surprise you with it. I used poor judgment. I wasn't going to hide it from you. There's a multitude of explanations, while untruthful, could have been given that doesn't cast aspersions upon the victim and doesn't put the victim through what he was put through. So this idea that it's a zero-sum analysis where the only way Mr. Siburn can protect himself from criminal liability is to attack and go after the victim, it just simply isn't true. He could have come up with explanations that does not gaslight the victim in the case, and to let it go on for as long as it has. Just as at hearing, Mr. Siburn did not share his version of events until hearing. Then all of these facts came out. Well, the hearing decision came out, and now, on the day of oral argument, Mr. Siburn now says, well, you know, he lied and perjured himself during the hearing. So at this point, I don't think anything has been shown to show that Mr. Siburn has been rehabilitated. I think he still seems to show that he does not understand completely the severity of his actions. Submitted.
All right, I'm going to ask our panel members if they have any questions. Mr. Siburn, I believe you already addressed the issue of penalty. Was there anything else you wanted to add before I open it up to questions with regards specifically to the penalty?
I had two more quick points to share, if that's okay, Your Honor.
Is it related to the penalty?
I just want to clarify the penalty of like what the ruling could be. My apologies.
Yes, well, what is being proposed in the proposed decision at this time, and what it is that you're requesting of the panel members?
I just wish to clarify one more point about supervision with the panel members, if that's okay.
Well, you don't ask the panel member questions. They ask you questions. Do you have a statement you wish to give to the panel members regarding the penalty?
I do, yes, Your Honor.
Okay, go ahead.
Thank you so much. Hopping off on the supervision of individuals in the operating room, I just wanted to state that due to the supervision and monitoring with checks and balances within the procedural suite, there's no need for a chaperone to be present during interactions with patients because there's so much checks and balances and oversight with an operating room staff, any procedural suite staff. I hope it is not assumed that because I made a bad decision while having an affair, that I would take a similar action while caring for a patient. Additionally, I wanted to highlight that I would still have, if I were to return to residency, I would still have around-the-clock supervision by a dedicated supervising attending anesthesiologist, as I have yet to complete residency. I would likely have to complete my full final year if I were ever to go back. I was 5 months away from completing residency when I was terminated, and that would be a full year of supervision during care of all patients. Additionally, I would have to complete a fellowship, which would be another full year of supervision. I would have ample time during that period of training to continue to prove to the medical board that I am not a safety risk to the public. Additionally, I would like to advocate for the ability to oversee advanced providers performing anesthesia, specifically CRNAs, physician assistants, nurse practitioners, anesthesia assistants, and anesthesia residents. There would be a dual line of supervision both over my practice and the other provider's practice. Importantly, it would be nearly impossible for me to get a job as an anesthesiologist if I am unable to oversee other providers. The current landscape of anesthesia employment is structured by anesthesiologists overseeing multiple providers in multiple procedural suites to deliver optimal, safe, and efficient care. Solo anesthesiology jobs are a dying breed, and has been well documented to cost healthcare systems more money when compared to overseeing multiple rooms. This would be a major hindrance to my ability to.
I object to this. That was presented in hearing.
So with regards to this, he's addressing the penalty and what is proposed with regards to probationary terms. And so I will allow that explanation because it's specific to the penalty. Mr. Siburn, please continue.
Nothing else to add, Your Honor. Thank you.
Right. I'm going to now ask our panel members if they have any questions, starting with the Vice Chair.
I have the question, Your Honor. Thank you.
All right. And then continuing with Mr. Brooks.
No questions, Your Honor.
Ms. Lawson.
Just one question. I think it's for the Deputy Attorney General related to Business and Professions Code 2234, which establishes what unprofessional conduct is. I know that you've made some argument and the administrative law judge found connectivity. Excuse me, while I get back to that screen. Connectivity between the physician's dishonesty and the qualifications, relationship, substantial relationship to the qualifications, functions, or duties of a physician and surgeon. Can you just please re-explain for me what your position is as to what the connectivity is?
So I won't be able to do it as well as Dr. Namba did because she went into a detailed explanation of the duties of an anesthesiologist and the standard that they're held to and why the reasons for all of that is. But specifically with this conduct, especially now that Mr. Siburn has admitted it, it is a misdemeanor. It's a criminal act that he committed against somebody. And it's an act essentially that has taken advantage of a vulnerable person. And so just as you could tie together, and the most common example would be a DUI or a domestic violence incident. Physicians are routinely held responsible for DUIs or domestic violence because those crimes show or have been routinely found to have a connection to the practice of medicine in that they are inconsistent with that level of professionalism and integrity that the public expects from the medical profession. And engaging in criminal conduct, and then of course all the other subsequent conduct is inconsistent with the practice of medicine, just as a DUI or domestic violence or other crimes would be. And again, Dr. Namba not only explained that based on her perspective as an anesthesiologist, but also cited to several sources and went through the different obligations that physicians, specifically anesthesiologists, have and connected it to the conduct that Mr. Siburn engaged in.
Thank you.
Ms. Lawson, any additional questions?
No, thank you, Your Honor.
All right, Dr. Mahmood, do you have any questions?
I remember this call, this whole thing I read, not today, but before I read everything, but I just wanted to, for a clarification from Dr. Siburn. Ever in your career in college and medical school, before this event in your residency, ever playing in a sports or being a part of any club, has there ever been any allegation on you, or have you ever done any criminal activity? Just answer no or yet.
Not. This is the first time anything like this has ever happened.
Okay, that's all. Thank you.
Any additional questions from our panel members? No. All right, Mr. Osley, is the matter submitted?
Submitted, Your Honor.
Mr. Firestone, matter submitted?
Submitted, Your Honor.
All right, the matter is submitted and the record is closed. We are off the record. All right, I'll turn it back over to our vice chair.
The panel will now go into closed session to deliberate on these matters and other proposed decisions and stipulated settlements. Thank you.